Hello, everyone. My name is Alex Anderson. I'm the anthropologist within the engineering and environmental staff at Rural Utility Service at Rural Development. I will be joined later by my colleague Steve Polacek, but I'll be starting our last presentation of the day, NEPA and Section 106. We're going to start with slides and the presentation, then transition into 10 to 15 minutes of Q&A. So we'll start with Section 106 compliance. The first step to starting the Section 106 process is to determine which consulting parties are part of the project. These are the entities you'll be reaching out to. These usually include the State Historic Preservation Office, also known as the SHPO, the Tribal Historic Preservation Officer, also known as the VIPO, and federally recognized tribes. While I understand that projects may cross tribal lands or serve tribal communities, it is important to note that the Tribal Historic Preservation Officer is a specific entity within the tribes, and they are authorized to make decisions about Section 106 and to identify areas and resources of interest to them. To determine which THPOs you will reach out to, you will use the Tribal Directory Assessment Tool, also known as TDAT. This is HUD's tool. Once you're in TDAT, you will identify the counties where the project will take place, and it will produce a list of I'm sorry for the technical difficulty. Okay. Hopefully we are back and everyone can follow along with their presentation. I'm going to start again at slide 6, completing Section 106 of the National Historic Preservation Act. So I was saying earlier that this is the first step in starting the Section 106 process. The first step is to determine which consulting parties are part of the project. These are the entities you'll be reaching out to. These usually include the State Historic Preservation Officer, also known as the SHPO, the Tribal Historic Preservation Officer, also known as the VIPO, and federally recognized tribes. While I understand that projects may cross tribal lands or serve tribal communities, it is important to note that the Tribal Historic Preservation Officer is a specific entity within the tribe. They are authorized to make decisions about Section 106 and to identify areas and resources of interest to them. To determine which THPOs you will reach out to, you will use the Tribal Directory Assessment Tool from HUD. Once you're in TDAT, you will identify the counties where the project will take place, and it will produce a list of tribes with interest in those counties. Their interest can be related to ancestral lands, previous migration, or reservation lands. Our U.S. does not have the authority to make decisions on federal or tribal lands. If tribal or federal lands are involved, please contact the National Office Cultural Resource Team. Special coordination with tribes and agencies is required. I will later list contacts for that cultural resource team, which includes myself, the Federal Preservation Officer, and the Deputy Federal Preservation Officer. Once you've identified the interested parties, please prepare the SHPO and DIPO initiation letters. The templates linked to the presentation have instructions and require you to fill in the project details. It will also require that attachments be appropriately referenced, included in the submission to interested parties, such as project maps and letters. Initiation letters are essentially project descriptions and information about the project location so that SHPO and DIPO, or State Historic Preservation Officers and Tribal Historic Preservation Officers, may check their internal databases to see if there are sites within concern near the project area. We ask that the applicant request a response to their letter within 30 days of receipt, but this is not a requirement of 36 CFR Part 800, the implementing regulations. We ask for a response within the 30-day window so we can proceed to the next step in the process. You may not receive a response to this first letter, and that is okay. We're hoping that SHPO and tribes provide information about sites or areas of concern within your project area so it can help us with the next step. In this next step, the applicant will hire a cultural resource consultant to help with identifying historic properties. When I say historic properties, I mean those that are listed and those that are eligible for listing in the National Register. Your cultural resource consultant should identify all those properties in their research. Once these are identified, they'll consider their nature and proximity to your project and make recommendations in their report to you. Make sure your consultant's report includes a recommended finding of effect. This finding and report should be referenced in your finding letter. As Steve mentioned previously, only an SOI qualified individual can perform this recommended finding or use their expertise to recommend a finding. If you have questions anytime within this process, please reach out to our US Cultural Resource staff. You may also reach out to us if your consultant's finding is anything other than no historic properties affected or no adverse effect. If the SHPO has not responded to the initiation letter after 30 days, that is okay. The finding letter is the next step in the process if you don't receive that response. Essentially, the finding letter is the determination of how your project could potentially impact historic properties. Once you've reached this point, it is time to proceed. If the SHPO disagrees with the finding, then please reach out to the RUS environmental staff. If you did not receive a response from SHPO or DIPO to your finding letter, and your finding was either no historic properties affected or no adverse effect, please make sure to explain in a written statement to RUS. The statement can be a part of your environmental information submissions. Please check the respective SHPO public sites for submission requirements. Some SHPOs require hard copy submissions, some require electronic submissions. If you're sending hard copy finding letters to SHPO and DIPO, please make sure you can get a delivery notification and you can submit such information, tracking information, to environmental staff with your statement if they did not respond to your letter. So on this slide, we've listed a number of scenarios. If any of these situations become apparent within the process, you should probably notify us, the RUS Cultural Resource staff, immediately. For one, if the project crosses federal lands, if the project crosses tribal lands, if the SHPO indicates there will be adverse effects to historic properties or a program alternative needs to be developed, if the SHPO, THPO, Indian tribe, or Native Hawaiian organization disagrees with the recommended finding of effect or determination of eligibility, or if the THPO or Indian tribe requests government-to-government consultation, or if another party with demonstrated interest in the project requests to be a consulting party or is in disagreement with the finding. Feel free to contact us. And again, if you have any questions throughout this process, please feel free to contact us. It's our job to guide you along in the process. This is where I have our contact information listed. As I mentioned previously, if any of the situations on the previous slide arise, or you're very confused as to where you are in the process or what needs to be done next, please contact the Federal Preservation Officer or our Deputy Federal Preservation Officer. Erica Martin-Seibert, there, the first bullet, she's our Federal Preservation Officer, and her deputy is Beja Howard, who's the second bullet. But you, the applicant, serve a pivotal role in this process. For example, if there needs to be any financing of required archaeological studies, you obviously need to be on board with that commitment if it's necessary. So we can have further discussion between us and the agency as to what's required, what studies may or may not be necessary, and what are the options as we move forward with the Section 106 process. You also may come into play when it comes to, again, committing to any other mitigants to avoid adverse effects. And that might include any changes in the project design. And again, you will be included in any kind of discussion of such to see if that's even feasible as per your project, and if you can indeed commit to it as a part of a mitigation condition. So I'm now going to pass the next part of the presentation over to my colleague, Steve Polachek. This may take a few minutes, so please have patience with us and stay on the line. You can take this opportunity to submit any questions you may have that I was unable to answer in the Section 106 compliance portion of the presentation.
Hello, everyone. My name is Steve Polachek, and I'll be covering the remainder of today's presentation.
Okay, so it looks like you're live now. My screen. So why don't you say something to the audience?
Okay. Technical difficulties, but I'll be back. I think I'm back now, and I'll be covering the remainder of today's presentation.
It looks like you're live.
So if you still have outstanding NEPA requirements, but Historic Preservation Act items that pardon me, as I was saying, extensive guidance on how to comply with the other laws, rules, regulations, and policies in our environmental guidance available on our website. Note that applicants must come to the Environmental Engineering Services branch if there's a ESA, Endangered Species Act, Section 7, finding of an adverse effect, finding of may affect, likely to adversely affect. Also, if the Section 106 finding is adverse effects to historical cultural resources. In general, for NEPA classifications, EIS, EA, and categorical exclusion, environmental impact statement, environmental assessment, or categorical exclusion. All of the projects for round one were classified as categorical exclusions. That is barring any extraordinary circumstances that may be discovered during the remainder of the environmental review process. So one of the, besides Section 6, Section 7 of the Endangered Species Act is one of the other major pending consultations that's required for completion of process. Section 7 applicants, requires agencies and then our applicants to understand the species that may be present in an area and how their action may impact those species. And to complete Section 7, informal consultation, a lot of this information in the application, but an official species list for the areas where the proposed project is to be located. With that species list, you identify that U.S. Fish and Wildlife, the species that could be present, and it's different for all of the species. Sometimes it's on county level, sometimes they have more refined data than the county level. But that just gives the agency and the applicant an idea of what species could be present in the area and if there is any critical habitat. Critical habitat is a defined area, a different relation that U.S. Fish and Wildlife puts out. Suitable habitat is different than critical habitat. Just because the official species list identifies that there is no critical habitat, it does not mean that there is no suitable habitat in your project area. Suitable habitat is the type of habitat that a pardon me. Suitable habitat is the type of habitat that a species can live in, whereas critical habitat has been deemed necessary for the continuance of the species by U.S. Fish and Wildlife. And again, it's something that's in regulation. It's a very specific area, or suitable habitat is just a type of habitat defined by regulation. So if your project has suitable habitat for the listed species on your species list, we need to identify if there is any means or methods in which your project could impact the species or suitable habitat. For most species, especially larger species that are free to move around, disturbed road right-of-way is not generally for many species. Say an endangered wolf, or can pass through the road habitat, but it's not somewhere that is particularly suitable for most of the wolf's life. Whereas there are other species, specifically some plant species, that do thrive in road right-of-way. Additionally, some other species, such as different types of burrowing species, maybe American burying beetle or the gopher tortoise, is a species that can be found in road right-of-way. Having a project that is completely within road right-of-way does not exclude the possible presence of suitable habitat. Another is bats. Bats roost in trees. If your project proposes any clearing of trees or cutting of any trees in the road right-of-way, and that could trigger additional consultation for listed bat species. So again, here are some examples of species that can be found and in some cases thrive in road right-of-way: the western prairie fringed orchid, Mottram sumac, and the gopher tortoise. And then it's actually associated with the gopher tortoise, there are some listed snakes that use gopher tortoise burrows as habitat also. So again, just being road right-of-way doesn't preclude it from having suitable habitat for listed species. So just a reminder that there are a few more workshop sessions coming up this afternoon and then on Monday. And we can move into the question and answer session portion. So we have a couple questions from the last session. So how does an applicant know if they have submitted the appropriate information for RUS to conclude the environmental review, and if that information is acceptable, and how will an applicant know that there is? So if you've submitted additional information to RUS, we will be reviewing it. If the information was incomplete or further action is required, RUS will indicate that through contact via email or phone or a follow-up letter. If you have not received notice from RUS that the environmental process has concluded, then you will know you are still in this limbo. If any of your letters indicated that there was some outside that RUS was taking the lead on resolving, then Mix It Tight RUS is working on it. If you are concerned that it's not moving at an appropriate pace, you can reach out to the environmental shop to touch base on where we are in completing those other requirements. Again, if you have any questions, you can always reach out to your general field representative, the environmental shop, or the servicing branch. We've got one question. After sending out SHPO-FIPO initiation letters, they've received no responses from the tribal entities within the 30-day comment period. This applicant has moved forward with the recommendations made by the State Historic Preservation Office, the SHPO, to perform cultural inventory. At this point, if the tribes have not responded to your initiation letters, there is no requirement to provide the finding letters to them. So you have performed a good faith effort under the Act to initiate communication with those tribal entities, and if they, then there's no requirement to submit a finding based on the cultural inventory that you're preparing. Note that does not hold true if the State Historic Preservation Officer does not answer an initiation letter. There is still a requirement to provide that office with a finding. Leave it open for a few more minutes to see if there's any additional questions. Okay, we'll leave this open for another minute, and if no other questions are submitted, wrap it up. If one additional is the inventory finding letters and concurrence from SHPO. Finding letters and concurrence from SHPO. So if all of those things are submitted all at once, you have concurrence from the SHPO, everyone's in agreement, there's no outstanding. That turnaround, assuming that the Section 106 process was your only outstanding item, it would be environmental shop and probably a few more days of processing to get the formal response out to an applicant, or to the awardee. If you have not received a response from the SHPO based on your initiation letters, you should propose a finding to the SHPO. We've provided those template finding letters in our guidance, both hyperlinked in the link and available online in the guidance section that was in the slide deck today. So again, if you've initiated the process with the tribes, and you have received no response, you're not required to propose a finding to the tribes, but you need to propose a finding to the SHPO. If after you've proposed a finding, 30 days elapses, and you've not received any input from the SHPO after those 30 days, the process would submit all those letters and some sort of affirmative statement indicating that you've not received any response from any of these entities. Let's review that. Again, the turnaround would be a few days, and then we would submit to you a formal that you've completed the environmental process. Okay, with no question. Well, if there are no more questions, again, thank you for joining us for our sessions today. If you have entered this webinar, please feel free to reach out to your field representative, the environmental shop, or the servicing branch. Thank you.